Hello, everybody, and welcome to another edition of Talks on Immigration with me, Attorney Carlos Wetton. Please stay tuned. Today, we are going to be talking about consular processing and also a little bit about the waiver process. So please don't go anywhere. Hey, everybody. Welcome to another edition of Talks on Immigration with me, Attorney Carlos Wetton. For those of you this is your first time tuning in, I am an immigration attorney with the law office of Jaime Barron, and we practice exclusively United States immigration law. And so this Talks on Immigration is an opportunity for us to discuss different topics regarding immigration law in the United States today. And today I am very happy to be joined by a fellow alum of St. Mary's University Law School, one of my good friends, attorney Iris Torres. Iris, how are you doing this morning?
I'm doing well. Thanks for having me on. I'm excited to be here.
Well, thank you so much for coming here. How's Dallas today?
A little cloudy, but the weather's nice. It's picking up, Texas bipolar weather.
Sure, of course. Well, here in Seattle, we actually got some snow last night. It's the first measurable snowfall that we've had so far this year. And so waking up to a little bit of snow and ice was a lot of fun.
Yeah, I bet it's cold over there.
It is very chilly. Well, thank you, Iris, again for joining us today. You and I are going to talk a little bit about something called consular processing. In previous episodes, I have talked with other attorneys about the residency process. We've also discussed fiance visas, but why don't we start with a brief introduction of what exactly do we mean when we say consular processing?
So what we mean by that is that certain applicants are required to go for their interview at the consulate. Either they're in the U.S. and they're required to leave to the consulate of their nationality, citizenship, to attend their interview, or they're currently abroad being petitioned, waiting for their interview as well at the consulate.
So these can be spouses, these can be siblings of United States citizens, they can be parents of United States citizens. In some situations, they might even be children of United States citizens or legal permanent residents. And so what you're explaining is that they're inside the United States, but for some reason they're not even eligible to apply for residency here, or they're abroad. Maybe you married somebody outside of the United States and they want to come in as a legal permanent resident, but because they're outside the United States, they have to have their interview abroad, correct?
Correct. That can include immediate relatives, such as spouses of U.S. citizens, parents of U.S. citizen children, minors of U.S. citizen parents, and that can also include siblings, legal permanent resident petitions for their children, for their parents. Basically, it's a whole spectrum of family petitions, but for some reason, they just can't adjust here in the U.S.
And so if you could talk us through a little bit what that process is like, because you can't just show up to the consulate and say, hey, I want to immigrate to the United States. Can you please give me a visa right now? There's a little bit of a process, right? Could you just kind of talk us through a little bit briefly what that process is?
Correct. So there's two options, right? Let's say you're here in the U.S. and for some reason, you're just not eligible to adjust your green card application here in the U.S., you have to go abroad. So that usually involves 3 steps. First step is your family petition. Second step would be applying for a waiver for an inadmissibility issue, specifically for unlawful presence. And then the third step would be applying for your immigrant visa so you can go to your interview at the U.S. consulate and get your immigrant visa so you can immigrate to the U.S. as a lawful permanent resident. So that's one option, right? If you're here in the U.S. and you have to leave abroad for your interview. The other option is you're already living abroad and you want to come in. Again, first step, petition. After that petition, we apply for your immigrant visa application, go to your interview. If all goes well, you get to come in with your immigrant visa as a lawful permanent resident.
Perfect. That's a great explanation of what those two options might be for someone who's not eligible to adjust here in the United States. So, Edis, you mentioned a waiver, and we've kind of talked a little bit about a waiver, of what a waiver is, and you also mentioned the word inadmissibility. And so, under the law, under the Immigration and Nationality Act, certain people are not admissible to the United States, correct?
Correct. You have to be admissible in order for you to able to adjust your permanent residence in the United States or even abroad. And for that, if you have any issues, such as you've been here unlawfully for X amount of time, you may be required to file a waiver to forgive that either 3-year bar or 10-year bar. It just depends on the amount of time you've been here unlawfully. But that's not the only inadmissibility ground, I'm sorry, such as unlawful.
It's a mouthful.
Yeah, such as unlawful presence. There's also grounds for, let's say, criminal issues, certain immigration violations, and that might require another type of waiver, of which you might have to apply after your interview if they found you to be inadmissible.
So you mentioned that we apply for this waiver, correct, Edis?
Mm-hmm.
So it's a separate application.
Correct. So going back to the first scenario, let's say you're here and you've accrued unlawful presence. We have the petition approved, and now the second step is the waiver. Why do we want to apply for this waiver first? Because the minute you step out of the U.S., that bar starts running. And let's say you go to your interview. Hey, you've been denied because you've accrued unlawful presence here in the U.S. So now you have to wait for this waiver outside. Well, the law permits us to apply for this waiver ahead of time. So when you go to your interview, no problems at all.
That's fantastic. So this is really an option for people who are, you said, some kind of an inadmissibility issue like unlawful presence. And there's a lot of people that have this issue. Maybe I've married, I'm a United States citizen, but maybe I've married somebody who entered unlawfully and they've been here 20 years. Well, if I want to petition for them, chances are they're going to need to apply for a waiver. But Edis, not everybody is eligible for a waiver. Is that correct?
That is correct. Unfortunately, right now, for a waiver, you have to have one of the two qualifying members. That is either a lawful permanent resident or a U.S. citizen parent, or a lawful permanent resident or U.S. citizen spouse, one of the two. Unfortunately, today, with the law as it is now, children don't count.
That's a question that I know I get a lot of during my consultations, and I'm sure that you get a lot of them as well. I have somebody who's been here 30 years, they entered undocumented, but they have United States citizen children. We've talked in the past that a child over the age of 21, a U.S. citizen child, can file a petition for their parents. But in this situation, we hit a snag that if that parent themselves don't have a U.S. citizen or legal permanent resident spouse or parent, then they're going to need a waiver. And if they don't have that qualifying relative, they're not going to be able to apply for one.
Correct. And on top of that, besides having this family member, you also have to show the extreme hardship it would cause to this family member should your waiver get denied and you have to comply with your bar outside of the U.S.
Wow. Okay. So we've kind of briefly talked about waivers in general, but let's go through kind of the different types of waivers, because we've mentioned that there's one specifically for unlawful presence, but then there's another for other kinds of issues. Why don't we talk about a waiver that we can apply for specifically just for unlawful presence?
Okay. Yeah. So for the unlawful presence waiver, let's go back to your example. You married a spouse, you are the U.S. citizen, you petitioned for your spouse, but your spouse has been here for 20 plus years unlawfully. They entered here without legal documentation, and since then they've remained in the U.S. So petition's been approved, and now we can move on to the waiver. Now, the only inadmissibility issue for your spouse appears to be unlawful presence. They've been here since they entered unlawfully for 20 plus years. So now we apply for this waiver. For this waiver, they can apply because they have you, Carlos, as a U.S. citizen, spouse. Now they have to show the hardship that it will cause you. How will you suffer without your spouse here in the U.S.? How do you depend on your spouse? They either provide some type of financial support for you. Maybe they're the breadwinner and you depend on them financially. Maybe you have some type of medical condition and they're your only caretaker. Or alternatively, maybe emotional or psychological hardship. You know, you'll suffer without your spouse here. You may get depressed. You might suffer with anxiety and stress, not having them here, not knowing when they're going to come back. And so we can show that hardship in different ways. As long as we can show that hardship to the officer reviewing the case, then you could get this waiver approved. Now, once it's approved, your unlawful presence has been basically forgiven, right? So the minute that your spouse is now eligible to go to the consulate, there should not be any issues, right? If this is the only inadmissibility issue they have.
Mm-hmm. That's a very good point. It's this particular waiver we call a provisional waiver. I mean, well, not just us, but USCIS will call it a provisional waiver, which means, you know, you put in all the work, you show hardship to the United States citizen spouse or parent or legal permanent resident spouse or parent. And USCIS is, once they approve their waiver, it's almost as if they're saying, okay, you've done your duty, you presented the evidence, we're going to approve this provisionally. But in this situation, it's actually up to the consular officer who's doing the interview for the residency, for the immigrant visa, to make that final decision of whether or not somebody is there, if this waived the inadmissibility, and whether they're eligible to enter the United States as an immigrant as a legal permanent resident. It's very, you know, this, in my opinion, as I explain this to people, this provisional waiver that waives unlawful presence is fantastic, because instead of, you know, in the past, someone would have to wait outside of the United States and they would leave and they would get their, you know, their determination, say, hey, you've been in the United States for 20 years. You have all this unlawful presence. You need a waiver. And they would be forced to wait outside of the United States for 1, 2, 3 years for their waiver to get approved, and they would be away from their families. At least with this specific type of waiver, they can stay here in the United States. They can be with their families until that waiver is approved, until they're scheduled for an interview.
That is correct. And to piggyback off of that, with the unlawful presence, like you said, provisional, right? So the ultimate final determination is by the consular officer reviewing the case at the interview. And that's the only inadmissibility issue. Mm-hmm. That's just for unlawful presence. We're not even talking about all the other issues that could arise. Now, mm-hmm. if there's some that arise at the interview, then guess what? We have to apply for another waiver.
Exactly. Let's actually discuss that. What other kind of inadmissibility issues? We've talked a lot about unlawful presence, but could you give us an example, Edis, of other types of actions or determinations or issues that could make somebody inadmissible and may need an additional waiver?
Yes. So some other inadmissibility issues would be, for example, fraud and misrepresentation or alien smuggling, maybe certain criminal convictions. So that's just to name a few. Maybe for example, you have to do a medical exam prior to your interview at the consulate. And if you fail your medical exam for whatever the reason may be, then again, we would have to apply for a waiver there.
Yes, there's a lot of inadmissibility issues that someone could have. A good one that you mentioned, or not a good one, but an interesting one, is this fraud and misrepresentation. I know in my experience with clients, sometimes I'll have somebody that maybe they have somebody else's tourist visa, or they have somebody else's documents, or maybe they weren't completely truthful on an application in the past. And so that the United States Immigration Service considers that to be fraud, misrepresentation in order to obtain some kind of benefit. It's lying to an immigration officer or another government official. And so that could be an inadmissibility issue, and someone may need a waiver for that. Now, I think there's an important distinction that we need to make, that sometimes you need a waiver for unlawful presence or other admissibility issues, not just when you're applying for a visa abroad, but also sometimes when you're in the United States. So just because you're applying or your spouse is applying for adjustment of status doesn't mean that you're completely free and that you're able to become a legal permanent resident. You also still might have some inadmissibility issues. Is that correct?
Yes, that's correct. So with the waivers don't only apply if you have to go outside of the U.S. for your consulate interview. They also apply if you're eligible to adjust your status here in the U.S. You might also need a waiver. So it could be determined at the interview stage. It could be determined prior to the interview. The officer reviewing your case while you're here in the U.S. determines, oh, you have this inadmissibility issue. You're going to have to apply for a waiver. The upside to that is that you're here, you're eligible to adjust your status here in the U.S. So you can apply for that waiver while being in the U.S. Wait a decision on that waiver. There's no need for you to leave the country.
Sure. And there's also, we mentioned having a qualifying relative, correct? So these waivers that we've discussed right now, you do need a qualifying relative. You do need somebody that you can show and you can point to and say, hey, this person, my qualifying relative, is going to experience hardship if I am not allowed to become a legal permanent resident and I'm forced to leave the country. But there are some waivers where you don't need a qualifying relative, correct?
That is correct. So depending on the inadmissibility grounds, depends on what the type of waiver you have to apply for, which also depends on whether or not you need a qualifying relative and what type of qualifying relative you need, right? So there's, for the most part, usually, like we discussed, parents or spouses that are either legal permanent residents or U.S. citizens. Certain occasions, you might need, or you could use your U.S. citizen or LPR children, legal permanent resident children. So it just depends on the waivers. Now, there's also other waivers where you don't necessarily need to show that there's a qualifying relative, but more so as ties and good moral character that you are deserving of this waiver because you've proven yourself.
That's interesting. And if somebody has been, so let's say that there's somebody listening right now who's a United States citizen, and maybe they have a parent that's outside of the United States, and that parent used to live here, but maybe they were placed in removal proceedings and they were deported and they were forced to return to Mexico, Latin America, Asia, wherever. And now it's been 10 years, they're outside of the United States. Are they able to come back through this consular processing? We've talked about, U.S. citizen kids petitioning parents, but let's say we have this situation with a parent who's been deported. Are they still able to petition for them? And is there a waiver available so they can come back?
Yes, so there is a waiver available as well. And this waiver basically shortens the time that you have to wait outside of the U.S., right? So this waiver could be used for, let's say you were deported previously and you have a bar that has yet to be completed. Let's go with a 10-year bar. And you're at the 4-month mark and you still have all these 4-year mark, and you still have 6 years more to go, then you can apply for this waiver to basically shorten the time so you don't have to serve the whole full 10 years. Unfortunately, with this waiver, that also comes with, for example, permanent bars, where you do have to, and you are required by law to comply with the full 10 years. But the fact that you complied all 10 years doesn't guarantee that, okay, you can come back in now. No, you complied with the full 10 years. Here's my evidence. I complied. Here's the waiver. So yes, that is also a possibility.
So I think it's important to mention here that if someone has a situation where they think they might be inadmissible, or maybe they want to petition for their parents that have been deported and are outside of the United States, if someone has a situation, the best thing that they can do right now before they begin any process is to give us a call, right? To schedule a consultation with you in Dallas, to schedule a consultation with me in Seattle, to schedule a consultation with our great attorneys in the Washington, D.C. area, so that we can answer their questions, evaluate their case, and then also kind of make a determination and say, a waiver is going to be needed. A waiver likely is not going to be needed. Here's what you can do. Here's what you can't do. I don't know about you, Edis, but I love giving consultations.
I do too, Carlos. And I think it's very helpful that we offer these consults for anyone that's curious and wants to know how long the process will take. When you consult with one of our attorneys, we can evaluate, see what your options are. And if we know that there's for sure going to be this possibility of needing a waiver, you know ahead of time. You are not going into your case blindly in the dark. You have an attorney by your side telling you each and every step of the way what's going to be needed.
Yes, exactly right. We'll walk you through the steps. We're never going to lie to you. We're never going to tell you, hey, I want your money, so come do this, even though you're not eligible for it. We'll always be honest with our clients, and we'll tell you, hey, if this is not something that you can do, then we're going to be honest and tell you and not get your hopes up. And so that's one of the things I love about working here is we are always honest with our clients. We definitely have this culture of honesty. And if there's a way to do it, if there's a way to become a legal permanent resident, then we're going to tell you and we're going to help you out. Edis, let's one last thing about waivers before we wrap up for today. How long are waivers taking right now? I kind of hear, different. I mean, we talked about this waiver for inadmissibility, and somebody can be in the United States waiting for this to be approved. How long do you think that will take, and why?
All right, so let's go to the unlawful presence waivers. Those are currently taking, from what I'm seeing, a little over 3 years. I'm seeing
Wow.
3.5 years wait time for a decision. Last one I received was back in 2020. It was received in 2020. It's just now being approved 2024. So that's how far behind they are on these waivers. I've noticed the trend basically at the pandemic. So pandemic happened, everything shut down, no one was working, and then once we opened up offices, started processing again, then that's when we started seeing movement. But unfortunately, ever since the pandemic hit, these waivers have been delayed.
Wow.
And what you're seeing right now on the screen, so that's for the unlawful presence, the provisional waiver we were talking about. Previous to that, that was another waiver for not just unlawful presence, but other inadmissibility issues. That one's taking less than 3 years, but we're still seeing over 2-year wait.
That was so our producer just had on the screen, that 43.5 months of what it's taking right now for that provisional unlawful presence waiver, which is the one that's adjudicated here in the United States while you're in the United States. 43.5 months. That's insane. I mean, that's nearly 4 years that you may be waiting for a waiver. And unfortunately, I wish it were faster, but we have very, very little control. In fact, we have no control whatsoever on the processing times. That really depends on USCIS, on their capacity to adjudicate these waivers. I know that last year I remember hearing through the American Immigration Lawyers Association that USCIS was going to build or was going to have different centers to process specifically these waivers because they're taking so long. I don't know if that's happened yet. I haven't really seen, things get better or things get faster. But it's also important for people to remember that USCIS is reviewing in lots of situations a mountain of evidence. We're having to show hardship. And so, and hardship can be financial, like you mentioned. It can be psychological and emotional. Maybe you have a health issue. Yeah, exactly. And so USCIS is having to review a stack of information. But once it's rest assured, if it was submitted, you have a receipt, it's processing. It just might take a little bit longer than maybe you expected at the beginning of your case, or maybe than even we expected at the beginning of the case. And so really it's frustrating. We completely understand that. But once that waiver is approved, then it's just a question of what, Edis? What comes after that waiver being approved?
Well, once that waiver is approved, we are one step closer to finalizing the case. As I explained, 3 steps. Final step would be applying for your immigrant visa application, which we do that with the Department of State. The Department of State then works with the consulate of your in your country of nationality, country of origin. And from there, we just wait for the consulate to schedule an interview for you, which could take a year and a half, depending on the country you're from, or it could take a minimum of 4 to 6 months.
Fantastic. And then let's say they go to the interview goes well, no issues, no other inadmissibility stuff. What comes next?
After that, you will get a decision from the consular officer at the interview. If you are approved, you will be leaving your passport there. Then you will get an update that your passport is ready for pickup with your immigrant visa, at which point you can immediately migrate to the U.S. as a legal permanent resident.
Then you're done until it's time to become a U.S. citizen, correct?
Correct.
Well, thank you so much, Edis, for joining me today. This was a great pleasure. Like I tell everybody, we're immigration nerds. I think we enjoy talking about this, and we do this because we enjoy knowing how it works, and especially because we enjoy helping our immigrant community no matter where they're at. Any last words before we sign off, Edis?
If you are curious about the process and you have someone that you know of, or you yourself are interested, feel free to reach us today. We are open and ready to take any consults that come our way.
Fantastic. And Edis especially is very ready. We're both very ready to talk to our clients and help everybody out. Well, thank you again, Edis, for joining me. And thank you everybody for listening and tuning in on this edition of Talks on Immigration. And we will see you next time.